Thank you very much, Honourable Chair. Honourable Chair, the committee does proposal that Rule 54 is amended. 1, by substituting for the head note the following: matters of urgent public importance. 2, by substituting for sub-rule 1 the following: a member who desires to raise a matter of urgent public importance shall, with the leave of the Speaker, raise the matter. 3, by inserting immediately after sub-rule 1 the following: 1A, in determining whether a matter should have urgent consideration, the Speaker shall ensure that the matter A relates to a genuine emergency calling for immediate and urgent consideration to warrant taking precedence over other business on the order paper, and B, has stimulated public concern or interest. 1B, a statement made by a member under sub-rule 1 shall be non-controversial on a matter of public importance or an emergency and shall not take more than 5 minutes of the House's time. 1C, the Speaker may order the member to resume his or her seat if, in the opinion of the Speaker, the member is not raising a matter of urgent public importance under sub-rule 1. 4, in sub-rule 2, by deleting the words shall be presented on Thursday and. This is the justification, Honourable Chair and colleagues. 1, to harmonize the head note with the content of the rule. 2, to streamline the procedure for raising matters of urgent public importance. 3, to require notification of the Speaker prior to raising a matter of national importance for purposes of ensuring orderly transaction of business in the House. 4, to ensure that Rule 25 sub-rules 3 and 4 on matters of urgent public importance are properly placed under Rule 54. And 5, to remove the restriction on the presentation of a statement by a member to Thursdays only. I beg to move.
Aisha?
No objection, Right Honourable Chair.
Thank you. I have seen the General Mujira. You have something to...
Thank you, the Right Honourable Speaker. On this Rule 54...
A matter of urgent importance, procedurally we have to meet the Speaker, and the Speaker will determine whether that matter is of urgent importance. That's why, while there, normally the Speaker calls the Minister to appear. But what is missing in this amendment is that a member meets the Speaker, brings a matter of urgent importance to the Speaker, but when he comes on the floor, he changes what he raised to the Speaker to something else. I think that's what should be reflected in this amendment. Otherwise, once the Speaker determines that someone's matter is of urgent importance, because it's within the realms of the Speaker to determine. So if someone comes on the floor and brings something outside what the Speaker was informed, that's what the amendment should bear. Otherwise, what I'm seeing here is quite very different. So, Mr. Chairman, could you kindly guide us on that? And that amendment should be fully reflected on the amendment. And I want to educate the honourable member, there's nothing wrong in pocketing in this House. It's my style of speaking, not from Chiwanda.
After amending Rule 54, does that mean we are deleting 49? Rule 49, notice of urgent questions.
Right, it's a question. Whereas matters of urgent public importance is a wider one. This one restricts to questions.
Yes.
That the person goes to the Speaker before he or she raises this matter was built on the presumption that we believe and we trust that the Speaker exercises good judgment to know that this is an urgent matter, that it fits within the rules. So, Madam Chair, I would propose that because we trust the Speaker, we don't again go on specifying what should be in the matter to be raised. Two, Right Honorable Chair, is about the fact that we are restricting this to Thursday.
No, we are
Sorry.
not. We are not.
Then I withdraw that.
You,
But
can you check Rule 49.3? 49.3?
the Speaker shall determine the admissibility of a question in accordance with Rule 44. I wanted to support Honorable Seungu to say that, Madam Speaker, we leave this to the Speaker. Once the Speaker is certified that this is a matter of national importance, then that it is very urgent in nature, then that person should not be restricted.
Read
by the
3
rules.
and 4. Read 4 too. Read 4 also.
49.
Yes.
A question without notes shall only be asked with the prior
No.
leave of the Speaker.
49.4.
49.4, where the Speaker is of the opinion that any question which a member has sought leave to ask without notes infringes any of the conditions set out in this rule, the Speaker may direct that it be printed or asked with such alterations as the Speaker shall direct, or that it be returned to the member concerned as being inadmissible.
Thank you.
Chair, Boseungu and Honorable Nambozi. Number one, you cannot access the floor unless with the leave of the Speaker. Number two, if you looked at C gives the Speaker the discretionary right to judge your matter, whether it's of urgent importance or not. And in case it doesn't, C says the Speaker will ask you to resume your seat. So all they are arguing for is being taken care of
Thank
in
you.
the
Thank you.
amendment.
Doctor?
Thank you very much.
Chair, we are trying to help the presiding officer determine what criteria does she use to determine,
She or he.
to determine that this is a matter of genuine emergence, immediate and urgent consideration to warrant this. So we are helping he or she to take a decision in accordance with the rule.
Of urgent public importance. You may find some people could be abroad or unable to be within the precincts of the Parliament, yet a matter of urgent public importance has occurred. Would we admit that a telephone call or an SMS or a WhatsApp communication to the presiding officer about such a matter would also suffice? Because you may not be physically present within the precincts of Parliament in order to bring this matter to the attention of the presiding officer.
Honorable Baigalo administrative. Real administrative. In most cases you've called, you have this problem. And we handle, we put it on the order paper, and we discuss it, we bring it as a communication. So that is administrative. Yes, Jessica. It has proposed and further amendment by Honorable Mujira. Those in favor say and the contrary nay. The ayes have it.
Rule 59.
59.